The defendant then followed the victim as he started to walk away. And at that point, he strangles him for several seconds with the sleeve of his sweatshirt. It was only when two teachers walked up and intervened that this concluded. The whole thing is on victim, or is on.
Your Honor, today is the date and time set for a PCC in this matter. We would be asking for an adjournment of the PCC to complete discovery in this matter. I have gotten some initial discovery, but I believe there is more coming after speaking with Madam Prosecutor.
That's the only thing holding him.
I'm sorry, Your Honor.
It's the only thing holding him.
Yes, it is, Your Honor. And we would like to address the matter of bond when the court is ready.
Cause conference, July 11th,
July 11th.
2024, 9 a.m. Or as your invite indicates.
Thank you, Your Honor. May I address the matter of bond, Judge?
You may.
Your Honor, Mr. Smith has no prior convictions other than possibly a driving while license suspension case. I did run his iChat and it was completely clean. He's been incarcerated for 9 days since June 18th. He has retained counsel and is serious about facing the matters in front of him. He's a 30-year-old man that lives in Ypsilanti and has an apartment he's prepared to go home to. He's a lifelong resident of the Metro Detroit area, growing up in Canton and graduating from Plymouth High School in 2013. He has extremely strong family support in this matter. His mom, dad, and sister all live in Canton, and his extended family out of the state has been calling to check in on Mr. Smith and help in any way they can. His mom is a assistant deputy director of field operations for the Michigan Department of Correction, essentially in charge of supervising parole and probation, or parolees and probationers. His dad is a retired worker from DTE Energy. His parents have borrowed from their retirement in order to retain counsel on his behalf. Speaking to Mr. Smith's work background, he's obviously resigned from his job due to this case, but he has been consistently employed since his senior year of high school, working in various industries like food service, manufacturing, trucking, and hospitality. He is confident that he can become employed should he be released in this matter, and he does believe he has a lead on a case or on a job to become a janitor. I have had a chance to review the police report in this matter, Judge. I would note that there's no mention of any injury to the complaining witness or no mention of any medical treatment. And based on that police report, I've done a preliminary run of his sentencing guidelines, and assuming for the sake of this bond argument only that if he were convicted of assault with intent to do great bodily harm and he were given points under OV3 for bodily injury requiring medical treatment, maximum points for psychological injury to the victim, and maximum points for exploitation of a vulnerable victim, his sentencing range would still be 0 to 17 months, meaning it would be an intermediate sanction since it's an under 18-month sanction. And as this court is well aware, jail is not an intermediate sanction. So that presumptively this would be a probation sentence.
I understand how sentencing works. Go ahead. Get to your end of your argument.
Okay. Concluding, Your Honor, I would note that there was 14 days between the arrest and the incident in this matter where there were no allegations of wrongdoing. Mr. Smith was proactive in looking out and getting a booked therapy appointment, which he would like to get back to. We'd be asking for a cash bond that Mr. Smith can afford because we do not believe he is a danger to the community or a flight risk. We'd ask for a $2,500 10% cash bond in this matter, Judge.
Response.
Your Honor, we originally requested $75,000 cash of surety in this case, and you were given $75,000 with 10% privilege. This is the case that was completely captured on video. Defendant is a teacher was a teacher at Ypsilanti High School. The victim in this case was a 14-year-old student. Here, the victim and the defendant appear to have gotten into a verbal argument. At one point, the defendant instructed the victim to do checks. The victim told the defendant that he was unable to do so because he had a wrist injury. And then at that point, the defendant got in the 14-year-old's face and said, "That's some bitch ass shit." The defendant then followed the victim as he started to walk away. And at that point, he strangles him for several seconds with the sleeve of his sweatshirt. It was only when two teachers walked up and intervened that this concluded. The whole thing is on victim, or is on video. And aside from the physical acts of the defendant, what is extremely concerning is that in his own words, in his statement to law enforcement, when asked what happened, he said he had a headache and he snapped and he knew it wasn't right. So I'm significantly concerned based off of the nature of the physical acts, which were all caught on video, but also the defendant's own admissions here about what exactly.
May I have a brief rebuttal, Your Honor? Even with the
There was
series,
a 14-year-old, he was a teacher, and there was a strangulation.
those are the allegations, Your Honor.
Yeah, go ahead with your response.
And even with the seriousness of these allegations, we fully recognize the seriousness. I think the guideline argument remains that this still is a presumptive probation. And I think to the danger of the community, I think the 14 days between between the incident and arrest where there was no court order in place, where there's no allegations of wrongdoing, speak to the danger of the community that Mr. Smith is. And I believe that that danger can be mitigated with reasonable terms of bonds, such as possibly a tether or a cash bond that he may afford, which we would ask for 2,500, 10%, Your Honor.
There's a 75,000, 10% bond.
I understand, Judge.
They didn't request that I raise it. I actually should raise it, given what I've heard. I will not. However, your motion for bond reduction is denied.
Your Honor, would you consider release if he was to live at his mother's house rather than by himself in Ypsilanti as a condition of bond?
And I thought I ordered something.
I was just asking if it would sway your decision at all, Your Honor.
No, when I'm done, I'm done.
Fair enough, Judge.
Thank you.
Thank you, Your Honor.
Violation of bond that we received. We would just ask that the sentencing be pushed out so my client can get back into compliance. As I said, I'm going to be walking her over to community corrections as soon as we're done here. And she is interested in resolving this case, Your Honor. She wants to enter a plea of 7411. I have the waiver here for the waiver of exam.
So she wants to waive up and plead.
Yes, that's correct.
Well, how do I know that she's going to get in compliance with this? Because she wasn't telling me the truth when she came in.
Your Honor, my client was, to say it in the simplest way, she was terrified, Your Honor. She understands that, there's no excuse for her behavior. Like I said, she's admitting to the violation at this time.
And I do apologize.
Well, what is she admitting to? Because she, first of all, blamed the jail. Then she blamed other people for not getting me. So what's the true,
Your Honor, she's willing to take responsibility that it was on her to figure out what she needed to do. And she shouldn't have waited for somebody to send her paperwork. She should have gone over to the courthouse, gotten the paperwork herself, gotten everything she needed, went to community corrections. She does want to rectify the situation, Your Honor. We do want to fix this. If the court deems additional testing, my client is open to that as well. So we leave it to the discretion of the court, Your Honor.
what do you do during the day?
I clean houses, Your Honor. I actually own a cleaning company, so. Yes, sir. I know. I have but one
Order, but a new order. But we're going to not do it quite that way. With the urine ET, it's intermediate drug testing urine and ETG 2 times per week. Ma'am, you're going to waive your right to a preliminary examination?
Yes, sir.
And you understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it. You understand that you'll not have that hearing and you'll proceed to circuit court for further resolution.
Sure.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on a single charge. Basie.
Yes, Your Honor. Thank you. We waive formal readings and stand mute to the charges at this time.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
It's August 12th at 1:30 before Slate Monday.
August 12th. But what is the other day?
The other day would be July 8th at 1:30.
August 12th. Pretrial will be August 12th, 2024, 1:30, Judge Slay,
Monday.
Monday. You admitted to the violation of bond, and her bond will be continued as previously said. I'm going to enter a new order that she'll have to comply with. Anything you want to say before I sentence you on violation?
No, just I apologize, Your Honor, for not being honest.
I don't even know why you did that.
I don't either. I'm old enough to know better, honestly. So
I really don't. I don't understand why you came in here. You're lying to me, you're lying to your attorney, you're lying to everybody.
I mean, I'm lying to myself. So I understand, Your Honor, and
Well, I always tell people, I'll deal with the truth and we can deal with each other when it's that way. But if you lie to me, that's
Difficult.
That's going to be the bigger problem. So I'm going to sentence on the violation, defendants to serve 5 days, Washington County Jail.
This courtroom hearing had two major moments, both showing exactly how quickly things go wrong when honesty and self-control disappear. First was the case of Mr. Smith, 30-year-old teacher accused of strangling a 14-year-old student. His attorney tried to convince the judge to lower his bond by pointing to his clean background, no criminal history, steady work, strong family support, and sentencing guidelines that suggested he'd likely get probation even if convicted. But the prosecution pushed back hard. They said the entire incident was caught on video, and according to them, Smith aggressively confronted the student, cursed at him, followed him as he walked away, and then used the sleeve of the student's sweatshirt to choke him until two teachers stepped in. Smith even admitted to police that he snapped, which immediately raised red flags for the judge. So when the defense made one last request asking if Smith could simply stay with his mother, the judge shut it down cold with the line, "When I'm done, I'm done." Bond reduction denied. Then came the second case, a bond violation involving a woman who came in with excuse after excuse. First, she blamed the jail, then the paperwork, then other people. But the judge didn't buy any of it. He asked her directly, "What is the truth?" Eventually, she admitted she didn't follow the bond rules and wasn't honest about it. The judge made it clear. Lying is always worse than the violation itself. He even told her, "If you lie to me, that's going to be the bigger problem." She was given 5 days in jail and her case was sent to circuit court. Both moments showed the same lesson. In a courtroom, honesty and responsibility matter more than anything. One person lost control, another lost credibility, and both paid the price.